Hello and welcome to week 5. Week 5. Last week was an amazing week, but week 5 is the death penalty, and we're going to discuss the death penalty. We're going to talk a little bit about Charlie Kirk this week in our discussion, and we're going to start there. Let me start there first with the discussion. Um, Let me share my screen. I'm sharing my screen now, so we should go into the content. Close this. Come over into week 5. Discussion, the death penalty. So there is a bunch of PowerPoints here. This one might be one that I actually want to look at. Yeah, this is the one I was looking for. And so we'll start with this one. So this week's discussion is with the idea of deterrence in mind. Do you think that the death penalty is effective punishment for general specific deterrence? Why or why not? And please defend your answer. For example, how will the imposition of the death penalty on Tyler Robinson affect society? Okay, if you don't know, Tyler Robinson is the man that assassinated Charlie Kirk. And we're going to talk about Furman v. Georgia here in a little bit as well. And I'm going to raise an important question about the Utah's promise to bring the death penalty against the assassin of Charlie Kirk. This is a hot topic. This is a controversial topic. This is a topic that will raise emotions. So whether or not you like Charlie Kirk, whether or not you are a fan of Charlie Kirk, whether or not you know anything about Charlie Kirk, hate him or like him, I ask you to keep this discussion respectful. No name calling, no celebrating the assassination, no promoting the assassin. This is an academic course, so we're going to use his name. His name is Tyler Robinson. And this is going to be an interesting thing. Normally, I teach the death penalty as a single topic. So I spend 17 weeks talking about the death penalty, the Supreme Court, the laws surrounding the death penalty, having debates whether you're for it or against it. And this is going to be one of those types of debates. I've put up a lot of PowerPoints and lecture notes this week, just so that you can have enough information. And then the quiz is hidden from you, so let me make it visible. Okay. And now the quiz is visible for you to take as well. The death penalty, well, let's just get into it. So, what is the death penalty? The death penalty is, let me hide this. There we go. The death penalty is capital punishment. It is the taking of a life. It is the prescribed execution of an individual who has committed a capital offense. Murder and a capital offense. The Supreme Court has ruled that the death penalty is not a violation of the Eighth Amendment. It is, the Eighth Amendment has made a ban on cruel and unusual punishment, and the Supreme Court has stated that it is not a violation of the Eighth Amendment. In fact, because of the Fifth Amendment and the 14th Amendment, the death penalty is constitutional. In order to change the death penalty in the United States, the individual states will have to make it. not illegal. They can't make it illegal. But what they'll do is they'll just make it a law that the death penalty cannot be imposed in their within their state. The Sixth Amendment does not require a jury trial on the sentencing issue of life or death. And again, not all states provide the death penalty. 38 states and the United States government provide for the death penalty as a final, ultimate punishment, ultimate sanction. So the history of the death penalty and the first established death penalty laws date as far back as the 18th century. BC, not AD, but BC, in the Hammurabi Code. If you've been to Intro to Criminal Justice, and it's a prerequisite, you have to have had Intro to Criminal Justice before you could have this class. It is important that you know Hammurabi, and Hammurabi's code was the first that codified the death penalty for 25 different crimes. The death penalty was part of the 14th century BC Hittite code. The 7th century Draconian code of Greece, which made the death the only punishment for all crimes. So under the Draconian, and we use the word Draconian laws and Draconian administrations because they are so harsh and brutal and strict with their punishments. The law of Greece, every crime that you committed against society was punished by death, period. The 5th century BC Roman law of the 12 tablets established an age of accountability and how old you had to be before you could be executed. And Rome set that age at 2. And most crimes, including theft, was punishable by death. So a 2-year-old toddler goes into the market and he steals an apple off of a countertop from a market space, and his punishment is death. Death sentences were carried out through crucifixion, through drowning, through beating to death, burning alive, impalement, even the Bible itself. And this has come up. Even the Bible itself establishes a death penalty, and that death penalty was by stoning. And we've heard a lot of people talking about how Charlie Kirk believed in the stoning death of the LGBTQ community. I think that's a stretch. Charlie Kirk believed in the Bible, but he also believed in Jesus as his Messiah. And he believed that through the acceptance of Jesus, any sin could be forgiven, and that the death penalty was taken care of. So I really doubt that Charlie Kirk believed in stoning of the LGBT community. But death sentences were carried out through those ways. In the 10th century AD, hanging became the usual method of execution in Britain. The following century, William the Conqueror would not allow persons to be hanged or otherwise executed for any crime except in the times of war. So we started seeing a moderation in the death penalty coming around, and at about the time of William the Conqueror. Okay, this trend would not last long, though. 16th century, under the reign of Henry VIII, as many as 72,000 people were executed for crimes against England. Some of the common methods of execution at the time were boiling, burning at the stake, hanging, beheading, drawing, and quartering. And we've got a video here I'm going to show here in a little bit of William Wallace and how William Wallace was executed. The executions were carried out for such capital offenses as marrying a Jew, not confessing to a crime, and even treason. Hold on a second. So The first executions in the United States in the new colonies was that of Captain George Kendall. He was executed in 1608 for being a spy. They said that he was a spy for Spain. In 1612, Virginia Governor Sir Thomas Dale enacted the divine moral and martial laws, which provided the death penalty for even minor offenses such as stealing grapes, killing chickens, trading with the Indians was a death penalty offense. You know, laws regarding the death penalty varied from colony to colony. Massachusetts Bay held its first execution in 1630, even though the capital laws of New England did not go into effect until years later. New York colony instituted the Duke's Laws of 1665. Under the Duke's Laws, offenses such as striking one's mother or father or denying God were punishable by death. A lot of, and this is where we get a lot of the thought, the idea, the debate that the United States was founded on Christian principles and Christian morals. Um, I'm thinking it was more like they were founded on Old Testament morals. Uh, the, the commandment, "Thou shalt honor thy mother and thy father," which is it's the fifth commandment. Um, you violated honoring your mother and your father, and you could be put to death under the Duke's Laws of New York in 1665. Some historical dates in history, in American history. Jane Champion was the first woman to be executed by hanging in James City, Virginia in 1602. A lot of states, by the 1800s, a lot of states reduced the number of their capital crimes and they built state penitentiaries. The first penitentiary was the Walnut Street Jail. And then there was Elmira and the Elmira System Prison. If you look through some of the pictures in the early weeks, the pictures on the week modules, you'll see pictures of Elmira. I went to Elmira a couple years ago, and that prison is humongous. Elmira was also the place of where the Union, not the Americans, but the Union had its prisoner of war camp was in Elmira, New York. In 1834, Pennsylvania became the first state to move executions outside of the courthouse yard and into the correctional facility. In 1846, Michigan became the first state to abolish the death penalty for all crimes except treason. In 1890, William Kemmler became the first person executed by electrocution. In 1907, between 1907 and 1917, there was a short-lived abolitionist wave that led to the repeal of the death penalty in Arizona and Kansas, Minnesota, Missouri, North Dakota, Oregon, South Dakota, and Tennessee. All but two of these states, all but two, would reinstate the death penalty. But to combat lynching and other forms of vigilantism is why they reestablished the death penalty. And we discussed it this last week about the blood feud, or I discussed it in a few of the discussions, the blood feud. So when we joined the social contract, we agreed that we would give up our right to vengeance for offenses against the self and allow the state to seek vengeance for us. And when the state stopped seeking vengeance and they stopped seeking the death penalty, we saw an increase in lynchings. So sexual assault and murder and things that would end up or result in where the state would normally execute you. Now they're not executing them. The families would get involved and they would start the blood feud again. The Hatfields and McCoys was one of these areas. The Hatfields and McCoys started with stealing of a pig, which turned into murder, and then Kentucky and Tennessee did nothing about it. So the families sought vengeance. The Hatfields went to the courts and they went to the government and they did everything that they were supposed to do uh, to seek vengeance against the McCoys. And nothing happened. So the Hatfields sought vengeance on their own. In 1924, the use of cyanide gas was introduced as an execution method. The use of cyanide gas was perfected on the battlefield of World War One, and then they started to kill people with it, and which I find mustard gas was also one of the chemicals used in World War One to kill people. That's now used. They've changed its name, and they give it to you in low doses. Mustard gas is now called chemotherapy, but that's another topic. In 1930s, executions reached its highest levels in American history. We averaged 167 executions per year in the 1930s. And there was something else going on in the 1930s. I'm going to give you a second to answer yourself and actually tell the computer screen, hey, it was this. It was the Depression because of economic turmoil. And we discussed this last week as well. And the week before we discussed this about if a turn in the economy would affect crime rates. Well, in the 1930s, we saw that the crime rates were increasing, and not just property crime, but crimes against persons, crimes against people, murder and rape and sexual assault and pedophilia and all of those things. Julius and Ethel Rosenberg in 1952 were convicted of treason and executed for selling atomic secrets to the Soviet Union. They were the first civilians in the history of the United States to be executed for espionage. There's some conspiracy theorists running around saying that they actually didn't commit the crime, but they were Jews, and there was a conspiracy theory that there was anti-Semitism to get rid of them and to kill them. So pre-Furman racism. Okay, Furman versus Georgia was 1972, and this is an important date. It's an important issue that's coming about, and there's no rhyme or reason as to who got the death penalty prior to 1972. But what we did know is that if you were black and your victim was white, you could be assured that you would get the death penalty. Between 1889 and 1918, 3,224 African Americans were lynched and executed by white lynch mobs. And this is not including those African Americans who were legally executed by the various states. Only 30 white people out of the 18,000 people executed in the United States between 1739 and 1944 were executed for killing African Americans. Got 10 murdered slaves, and 2 of those 10 were slave owners prosecuted for destroying property under the laws of the day, not for the destruction of a black life. In a 1918 report on the black population, the Bureau of Census noted that while blacks made up about 11% of the general population, they made up about 22%, or 1/5 of the inmates in prison. And this was over 100 years ago, 117 years ago, 109 years ago. Okay, and this hasn't changed. This statistic has not changed at all. Today, we're seeing that the African American population makes up 14% of the total population. They're 50% of the people in prison, and they're 36% of the people on death row. They are extremely overrepresented within corrections. And I know some of you brought up mass incarceration, and we can discuss race and racism this week in the discussion of the death penalty on whether or not the death penalty is a deterrent factor. Okay, pre-Furman discrimination was mostly made up of rape cases. Before Furman, if you were a black man and you raped and even sometimes have consensual sex with a white woman, you would be put to death. Okay, so um, and this is tasteless in advance. So if this offends you, I am sorry. Um, but prior to Furman, it was known logic that if you were black and you raped a white woman, you were going to be executed. If you raped a Hispanic woman, you were probably going to prison for the rest of your life. If you raped a fellow black woman, it would probably be ignored. If you were a Hispanic man and you raped a white woman, you would probably most likely end up in death row and be executed. If you raped a Hispanic woman, you would probably end up in prison. If you raped a black woman, it would be ignored. If you're a white man and you raped a white woman, depending on the severity of the rape, you would go to prison. If you raped a Hispanic woman, you would pre-Furman, uh, you would go to jail. You'd serve a little bit of time, but it wouldn't be serious. If you raped a black woman, it would be celebrated. It would be ignored, and it would be, nothing would occur. It's sad. Studies have proved that blacks were executed more often than whites prior to Furman. So, Trope versus Dulles in 1958, the court stated that the Eighth Amendment contained an evolving standard of decency that marked the progress of a maturing society. Trop was not a death penalty case. Abolitionists applied the court's logic to executions and maintained that the United States had in fact progressed to a point that its standard of decency should no longer tolerate the death penalty. And this was the precedent that was used coming into and looking at Furman. That the United States has evolved to a first world nation. And as a first world nation and a world superpower and trading with the entire world and connections in every corner of the world, we should be above and beyond the idea of the thought of having a death penalty. Only the barbaric third world nations use and have the death penalty is what their argument was. Okay, in Jackson, U.S. v. Jackson in 1968, the court said, we agree with the district court that the death penalty provision of the Federal Kidnapping Act imposes an impermissible burden upon the exercise of a constitutional right. We think that provision is severable from the remainder of the statute. There is no reason to invalidate the law in its entirety simply because its capital punishment clause violates the Constitution. The district court therefore erred in dismissing the kidnapping count of the indictment. That is what is disputes is the conclusion that the statute thereby subjects the defendant who seeks a jury trial to an increased hazard of capital punishment. The government constitutes a statute that a defendant who elects to be tried by jury cannot be put to death, even if the jury so recommends, unless the trial judge agrees that capital punishment should be imposed. Okay, in 1968, Witherspoon versus Illinois, the Supreme Court held that a juror's mere reservations about the death penalty were insufficient grounds to prevent that person from serving on a jury. Jurors could be disqualified only if prosecutors could show that a juror's attitude towards capital punishment would prevent him or her from making an impartial decision about the punishment. Okay, so Witherspoon and Jackson started a 10-year moratorium on the death penalty. And then the big case comes in 1972. It was actually three cases: Branch v. Texas, Jackson versus Georgia, and Furman versus Georgia. They were all wrapped up together, and they were decided in what we commonly know as Furman v. Georgia. Furman v. Georgia, and the lawyers for Furman v. Georgia, Jackson, Georgia, and Branch, Texas, argued that the capital cases resulted in arbitrary and capricious sentence. Furman was a challenge brought under the Eighth Amendment. You know, what they said or what they claimed was that because there was no logic in who received the death penalty, there was no instruction for the jury, and the idea, the principle set forth by Caesar Beccaria, stating that punishment should be swift, certain, and proportional. It should also be equitable. And I know that there's been a whole big thing about DEI, but punishment should be equitable. If George Jones, good old white boy, gets sentenced to prison for X offense, everybody else that gets sentenced to X offense should receive the same punishment. But because prior to Furman, the punishment was so non-conforming, they said that it violated the Eighth Amendment. Okay, it was cruel and unusual if it was too severe for the crime. It was arbitrary if it offended society's sense of justice, or if it was not more effective or less than a severe punishment. Okay, was there a lesser punishment that was more effective to change the behavior and the attitudes? Supreme Court effectively voided 40 death penalty statutes across the country. It commuted the sentences of 629 death row inmates around the country and suspended the death penalty because existing statutes were no longer valid. Every existing statute for the death penalty was ruled unconstitutional. Justice Black, Hugo Black, stated that the death penalty as it was being practiced across the nation was barbaric and should never be seen in a civilized community. So, but they didn't outlaw the death penalty. The only way to get rid of the death penalty is through an amendment. Article 3 of the Constitution talks about the only crime that is afforded the death penalty, or the only crime that's discussed in the Constitution is treason, and its punishment includes the death penalty, and the punishment will be set by Congress. Okay, so it's going to require a constitutional amendment to get rid of the death penalty in the United States. So it's something that we are going to live with, or we're going to have to live with, because the death penalty is constitutional. The Fifth Amendment and the 14th Amendment guarantee us the right to due process, and that we cannot have our life, liberty, or property taken from us without due process. And due process is the process, and it's the process that we have been discussing in criminal justice. We teach you the system. We teach you due process. If you learn nothing else in your criminal justice career, I hope that it's due process, and it is the due process amendments. The due process amendments are the Fourth Amendment, the Fifth Amendment, the Sixth Amendment. Some people say the Seventh Amendment, the 18th Amendment, and the 14th Amendment. Okay, so we sit here and we are in 1972, we're sitting in a place to where the death penalty has been ruled unconstitutional and violated the Eighth Amendment and the due process clause of the Constitution. So the states, Georgia, Texas, and Florida, got together and they started working on finding a constitutional way to provide for the death penalty. So collectively, it's known as Gregg v. Georgia in 1976. The new death penalty statutes in Florida, Georgia, and Texas were deemed constitutional. They reinstated the death penalty in those states. The court also held that the death penalty itself, excuse me, was constitutional under the Eighth Amendment. So there were several reforms to the application of the death penalty. And this included a bifurcated trial in which there are separate deliberations for guilt and penalty phase of the trial. Okay, so now if you plead guilty to a capital offense, the death penalty is automatically taken off the table, because you cannot be found guilty or ruled guilty. You cannot go against the Fifth Amendment and testify against yourself and then receive the death penalty. Okay, so if you plead guilty, that's a violation of the Fifth Amendment. If you plead guilty, they can't execute you. Okay, so you have to have a jury trial. The jury trial must find you guilty, and then a guilt phase must also find that you are eligible for the death penalty. Okay, an automatic appellate review for convictions of sentences. And the way that Texas did this was they established the criminal court, the Court of Criminal Appeals. And the Court of Criminal Appeals is required to review every death penalty case within 180 days to make sure that the Texas Constitution was fulfilled and met, and that the U.S. Constitution was filled and met. Yeah. It was a proportionality review, and the proportionality review was a practice that helped the state to identify and eliminate sentencing disparities. Okay, so through this process, the state appellate court can compare the sentences in the specific case versus other sentences in other cases and other similar cases. Are all of these cases ending up with the death penalty? Are they ending up with the death sentence? Okay, and if it's not, if there's disproportionality going on, and there's more African Americans being executed for this crime than whites or Hispanics, then the death penalty is set aside. So if you go to the Texas death row page, you'll see that there are more whites on death row waiting to be executed than racial minorities. Is it still proportionately disproportionate? Yes. However, most of the African Americans who are on death row come out of the Houston area. Most of the Hispanics come out of the San Antonio area, and the whites come out of the rest of Texas. In that 85% of Houston and 90% of San Antonio are the respective racial and ethnic minorities. So now all of a sudden it's not disproportional from the jurisdiction where they were committed. So Gary Gilmore. Okay, so we've got Utah on the screens again. So, and after 1977, after waiving all of his appeals and convictions for murdering a hotel clerk and a gas station attendant during a robbery, Gary Gilmore was the first person executed in the United States since Furman. Okay. He sued the United States government and the state of Utah to be executed. He actually said that if I am ever released from prison, I will continue to murder. It is important that I get executed. He was executed by firing squad, and his last words were, "Let's do it." There was a Tommy Lee Jones movie, and I forget the name of the movie, um, but there was a Tommy Lee Jones movie that follows the story of Gary Gilmore and the reinstitution of the death penalty. Coker v. Georgia, and I alluded to this a little while ago. I alluded to this with the Charlie Kirk case and the promises of Utah to bring Mr. Robinson to the death penalty, or to bring the death penalty in this case. Coker v. Georgia, 1977, ruled that the Eighth Amendment forbade the death penalty for a crime of rape of an adult woman. Okay. They said that while serving several sentences for murder, rape, kidnapping, and aggravated assault, Ehrlich Anthony Coker escaped from prison. While he was out of prison, he broke into Alan and Anita Carver's home, raped Anita Carver, stole the family's vehicle. Coker was convicted of rape, armed robbery, and other offenses. Okay. He was sentenced to death on the rape charge after the jury found two of the aggravating circumstances present for imposing the death sentence: that the rape was committed by a person with prior convictions for capital felonies, and that the rape was committed in the course of committing another felony, armed robbery. The main consequence of Coker was that the death penalty in the United States was largely restricted to crimes in which the defendant causes the death of another human being. Recently, however, some states are testing that limit of this restriction by enacting the death penalty statutes for repeat child molesters. And we discussed that in the research discussions. But so what came out of Coker v. Georgia is that you have to kill somebody while committing another felony. Okay. So you have to commit robbery, or commit rape, or commit car stealing and kill somebody. Okay. So even though Coker raped this woman, he stole their car under gunpoint, he robbed some stores, he did all of these crimes, he didn't kill anybody. And this brings my question, and we can discuss it in the discussion forum. If you have to commit another felony in the process of committing murder, or you have to take a life in the process of committing another felony before you qualify for the death penalty, does Mr. Robinson even qualify for the death penalty? Or are we just, or is the state of Utah just looking for vengeance because the state of Utah will forever be known as the place, the university, the public school system, to where Charlie Kirk was assassinated? So in your discussions, I need you to go find the court cases. I need you to go find, to be able to stand one way or the other on whether or not Utah has standing to execute Mr. Robinson. So, lethal injection. In 1982, Texas became the first state to use lethal injection as capital punishment for the execution of Charles Brooks Jr. The intravenous injection is usually a mixture of compounds designed to induce rapid unconsciousness, followed by death through paralysis of the respiratory muscles, and including cardiac hyperpolarization. Okay, so we we stop your breathing and we stop your heart. So the three drugs that are most commonly used is sodium thiopental, turbocarine, and potassium chloride. The potassium chloride stops the heart from beating. However, the Benadryl type, the sodium thiopental, puts you in a state of unconsciousness and you will never wake up anyway. You might, it won't kill you, but you will never wake up. You will be in a coma for the rest of your life. The tubocaine stops all of your muscle movement except for your heart. This causes muscle paralysis. It collapses the diaphragm. Eventually, you would just die of asphyxiation because you wouldn't be able, your lungs aren't working. It stops your diaphragm. It stops everything from working except for your heart. And then potassium chloride stops your heart. In 1986, Paula Cooper was convicted in the 1985 torture, murder, and robbery of a 70-year-old Bible teacher, Ruth Pelkey, in Lake County, and was sentenced to death. Pelkey was stabbed 33 times on May 14th in Gary, Indiana. The assigned public defender advised Paula to plead guilty. Jack Crawford prosecuted the Lake County case. Judge James Kimbrough sentenced Paula to death. She was 15 years old at the time of the murder. She was the youngest person ever on the Indiana death row. In 1989, the Indiana Supreme Court vacated the death penalty, holding that murderers less than 16 years of age cannot receive a death sentence without violating U.S. and Indiana Constitution, substituting the maximum allowable prison sentence at the time, which was 60 years, with a minimum term of 26. Okay, so is the death penalty still racist? And so the race of the death penalty, 34% are black, 6% are Hispanic, 57% are white, and 2.3% are other. So if we're looking at that, when in a community, in a country, in a nation, in a society, where the African-American population makes up 14% of the total population, they are more than double represented on death row across the country. The Hispanics are underrepresented on death row, and so are the whites, who make up 75% of, I think that number is going down, but the whites are over 70% of the population are white, and they're only represented 57% of the time. Wanting to say that, you know, the Hispanic population is between 10 and 20% nationwide at the moment, and they're also underrepresented. And I'm wondering if religion or Catholicism has something to do with that number. Just a thought, because religion is really important in overall in the Hispanic culture. Victims, race of the victims since 1976. The offenders that are on death row, their victims were 14% were black, 4% were Hispanic, 79% was white, and 32% was others. So we're still looking and seeing that if your offender is white, not the offender, but the victim is white, you are still more likely to find yourself on death row. Okay, so Texas has an express lane. These are the number of executions. I know this was between 2006. I probably need to update this marker, and all my cows have come up. I guess they're wanting to get fed. Current populations also from 2006. I need to update this. Texas is now down to 380 something people, but I think that's because they've executed them. All right, so I lost my mouse. Hold on. So let's talk about the Supreme Court a little bit briefly. If I find my mouse again, the sun's starting to get bright. Okay, 1968 death penalty cases. We've already covered them. McGurtha versus California, Compton versus Ohio, 1971. The court rejected McGurtha's claim, and they tacitly approved unfettered by jury discretion in death sentencing. They tacitly approved capital trials in which guilt and sentence were determined in one set of deliberations. Okay, and this would be changed by Furman versus Georgia, and it held that capital punishment sentences statutes were unconstitutional. Um, Mandatory death penalty statutes and guided discretion death penalty statutes were now approved through the Gregg case, Woodson versus North Carolina, the Roberts versus Louisiana, 1976. The courts rejected mandatory death penalty. Okay, so now the states cannot demand that you be executed, which, you know, we might have this coming up. Woodson versus, you know, the court rejects mandatory death penalty sentences. And if the governor is stating that we're going to have the death penalty for Mr. Robertson, does this violate these cases? Gregg versus Georgia, we've covered. So the three most common types of guided discretion is aggravated versus mitigating circumstances, which is Florida. Structured discretion is by Texas. Aggravated only is by Georgia. The capital felony, so Texas has, you have to ask these three questions. Is this a heinous crime? If released, will this offender commit this crime again? And the third one is, are there no other options? Is this man beyond rehabilitation? Florida's 11 aggravating circumstances include, was this offense committed while under community or under state sanctioned supervision? Was it previously convicted of another capital felony? Was the defendant knowingly created a great risk? Capital felony was committed while the defendant was engaged or his accomplice in the commission of or an attempted commit an act. I don't need to read all of these to you. They're all there. Florida also has 7 mitigating circumstances that could avoid the death penalty. And I'm not going to read those. Okay, the jury issues of Texas is structured, is whether there's a probability that the defendant would commit criminal acts of violence if he was freed. Okay, whether or not the defendant actually caused the death or the deceased or did not actually cause. Everything is in 1996, 36 of the 38 states with capital punishment provided for an automatic review of all death sentences, regardless of the defendant's wishes. Okay, Arkansas has no specific provisions for an automatic review. South Carolina allows the defendant to waive sentence review and if the court deems that the defendant is competent. Okay, the federal jurisdictions does not provide for automatic review. In most of the 36 states will automatically review both conviction and the sentence. Idaho, Indiana, Oklahoma, and Tennessee review only the death sentence, not the sentencing itself or the finding of guilt itself. Okay, it's considered a desirable. Supreme Court does not require it, and that's proportionality review. And some states do have proportionality review, such as Texas. Post 1976, the constitutionality of the death penalty statutes, they've discussed what crimes are capital, which crimes are not. They've discussed mitigating circumstances, aggravating circumstances, the appeals process itself, capital juries, and whether or not, and who may or may not be executed. There's an age limit on executions now of 18. The mentally handicapped cannot be executed, and other procedural contents. The constitutionality of the death penalty statutes in Harry Roberts versus Louisiana, mandatory death penalty statutes were deemed unconstitutional. Sumner versus Sherman, mandatory death penalty statutes were unconstitutional, even if they confined to a special category of offender, such as a killing by an inmate or serving a sentence of life imprisonment without the possibility of parole. Blystone v. Pennsylvania, the court upheld Pennsylvania's death penalty statute, even though it mandated a death sentence in the jury finds at least one of the aggravating circumstances and no mitigating circumstances. McCluskey versus Kemp, the state death penalty statutes were found constitutional, even if they find that they've been racially biased. Racial discrimination must be shown on a case-by-case sentence. Bays et al. Versus the Commissioner of Kentucky. It was decided in 2008. The Supreme Court held that the lethal injection is constitutional. It does not intentionally inflict pain and does not violate the Eighth Amendment, as ruled in Wilkerson versus Utah. Donald Roper versus Christopher Simmons was decided in 2005. The court held that the 8th and 14th Amendments forbid the imposition of the death penalty on offenders who are under the age of 18. Atkins v. Virginia. Executions of the mentally retarded criminals are deemed cruel and unusual punishment, which brings us back to Ricky Rector and the state of Arkansas. Rector was executed in the 90s. I don't think that he would qualify today. Coker v. Georgia established what crimes are capital, and you have to kill somebody in commission of another felony. Lockett v. Ohio, Bell v. Ohio, trial courts must consider mitigating circumstances that defense attorneys present, and not just those listed in the statute. Skipper v. South Carolina, was convicted murderers trying to escape the death sentence because of their good behavior. They tried this with Carla Faye Tucker. That tried to escape the death penalty because they were reformed and were saved and were born again. Such evidence must be considered as legitimate mitigating circumstances, but does not overturn. Hitchcock v. Duggar, sentencing authority may not refuse to consider any relevant mitigating circumstances. Carrying on with the mitigating circumstances. Godfrey versus Georgia looks at the outrageousness of the crime and aggravated circumstances. There's one, so Walton v. Arizona, for statutory aggravated circumstances such as the one in the Godfrey case. To withstand constitutional challenges, a state high court must adequately clarify its meanings, and that meaning must be applied independently to the facts of the case. Barefoot v. Estelle, which is a Texas case. Psychiatric evidence predicting future dangerousness is admissible. There was a movie that came out about this, and that was called The Minority Report. Zant v. Stevens, a death sentence does not have to be vacated if one of the 3 statutory circumstances were found. There's just a whole lot of cases here. Barefoot versus Estelle. Courts can deny an application for a stay of executions on habeas appeal, which was rarely ever done before Barefoot. Pulley v. Harris, also a Texas case. The state appellate courts are not required to provide, upon request, proportionality review. Woodward v. Hutchins and Antone versus Duggar. The Supreme Court will not consider issues raised for the first time pursuant to the last-minute pleas or stays for execution. Cows are getting even closer to my deck right now. So there's a whole lot of information here, a whole lot of court cases that I'd like you to review before you proceed with your discussions. Let me escape this. Let me... Trying to see if I can figure out how to stop sharing. Stop sharing. Okay, so here we are. To stop sharing, my cow's right there. We've been at this for a little while, and like I said, this is a class. I teach the death penalty class for a full semester. If this is something that you might be interested in, you'd have to go petition. You'll have to go to petition the Criminal Justice Department. But I'm just an adjunct. I teach at the will of Arkansas, at the state of Arkansas. But this is one of my favorite topics, and I could talk about the death penalty forever. Hopefully, you don't know which way I stand. Maybe in the discussions, you might get an idea, or you might think that you know how I stand on the death penalty. But here we are. Next week is another week. I'll see you guys in the forums. I hope that you guys are enjoying this class. Let me know. I'll get all of this loaded up onto YouTube. I'll load it into the Lion's Den, and I will load it into week 5. But beyond that, I will see you next Monday, and I will see you right here in the forums.